Hi everyone, we're here with Anna from Batten Sachs. Anna is a wills and estates attorney, correct?
That's correct. Wills and Estates lawyer.
Lawyer. Perfect.
It's all the same.
Perfect. Anna, it was actually great to meet you during a networking session. You came across as very, very friendly, someone who really wants to look after their clients. So I thought we'd catch up. And as you know, I do year-end business tax planning with my clients. And one of the conversations we sometimes avoid, but are very, very important, is the topic of wills and estates and death. So can I ask you, why is the topic of wills and estates important?
Yeah, so it's a fantastic question. So wills are important because obviously they're the documents that govern what happens to your hard-earned assets after you pass away. So for instance, if you have property, if you have assets, it will specify who the beneficiaries of those assets are. Generally speaking, a lot of us that acquire wealth like to be in control of that wealth. So it makes sense that we'd like to have that control. Not so much beyond the grave, but in the sense that we need to have a clear direction for the legacy that we leave behind. Most of us like to look after our loved ones. So that's why a will is a very important document that specifies where all of our assets go and to whom and in what proportions. And I suppose the biggest risk of not having a will is that the government has a will in place for you. That's called the rules of intestacy. And it could be the case that there's certain family members that you wouldn't want to benefit from your estate, but if you don't have a will in place that specifies exactly what you want to happen, the risk is that those beneficiaries that you didn't want to receive something out of your estate will then benefit.
So can that be challenged in court, and how do we protect against that?
Yeah, absolutely. So even though a will is the best way to maximise compliance with the document, of course a will can be challenged, but there is a very limited class of people that can challenge the will. So I'd still recommend that a will that's drafted by a lawyer with I suppose all of the instructions taken into account, individual personal circumstances, will still go a very long way to ensure that we can minimise those sorts of challenges. But also it's to do with property ownership. So I suppose this is where wills and estates collides with a bit of family law and property law and understanding the structures. So sometimes doing a deep dive into these things and understanding how asset portfolios are owned and held will be able to allow us to get to those outcomes. So it may not necessarily be the strategy that we come up with within a will. It could be a separate trust that's created, but at least if we understand what the, I suppose, sensitive and trigger points are for a client, we can then work towards mitigating those risks.
Fantastic. Now you mentioned assets, and I'm just curious, what assets can we pass down to our loved ones through a will? Are we talking about just property, or does, say, businesses come into property? Say if I'm owning, or I'm holding shares, units and unit trust, that type of thing.
Absolutely. Even pets can come under the will.
Even pets?
That's right.
There you go.
Cryptocurrency, the works. So that's some of the more exotic assets, if you like. But I suppose the big ones that we talk about are shares in listed companies, real estate property, cars, all of the homewares that we acquire and furniture. But absolutely spot on. It's really important to understand also if there are businesses that we need to include in the will, particularly if we operate a family trust. It's really important as to who controls that trust, because whoever the shareholders are can then obviously become the directors after we've passed away. So sometimes it's not necessarily as important as the shares that we leave, but the appointer that we appoint, because they will have the ultimate control. So we can definitely deal with those things for our privately held companies, and it's
And they'll become
important.
through the will, okay?
Yeah.
Who the appointer is. I guess through the will and through the trust deed itself.
Yes, that's
So, yeah.
absolutely right. So that's why we need to do a deep dive and
Right.
an audit,
Make sure
if
all
you
those
like.
documents, right, okay.
So that we're all singing from the same prayer book, if you like, to make sure that we've done a holistic approach to everything.
Yes.
So that all of the documents move into the one direction.
Yeah, I would gather, include things like shareholder, unit holder agreements too?
Absolutely. So I think that what you're touching on there is business succession planning and understanding if something were to happen to us, whether that be death or total permanent disability, there may be some agreements in place in a shareholders agreement, for instance, of where those shares are going to go to next, whether that's our business partner that's not connected to our family unit, but we want our family unit to ultimately benefit from the hard work that we've put in to that business.
Yeah, agree.
Yeah.
So the next question I've got for you, I think I've already asked a few. That's not the second or the next question. Is when is a good time to look at having a will done?
It's a fantastic question.
And probably, sorry to cut you off there, and probably, I'm thinking there's probably different times where we might need to change the will. Is that?
Yeah, that's absolutely spot on. I think you've answered your own questions there for sure. But I think that the second that we start acquiring any type of assets, we should have a will in place. And usually what that sort of means to people is that they say, oh, I've just got a car. I haven't bought my first home yet, so it's not important. Because unfortunately, people forget that they have this thing called superannuation.
Yes.
And a lot of the time, it's one of those forgotten assets because through our superannuation, we usually have life insurance. And if something were to happen to us, more often than not, there's quite a hefty amount of money that our family members or our beneficiaries can usually benefit from. So I suppose... basically, anybody over 18 should be looking at having a will in place, even if it's a very simple one. And in particular, super is something that we need to have a chat about. So I'm just going to ask myself some questions and reply. Is that in the sense that super has a very limited class of beneficiaries. So you can only leave your super to your spouse, a child, or a dependent. I'm sure you'll know all about the cis beneficiaries and everything like that. The fourth category is the deceased estates. So for instance, if I was in a situation where I didn't want my partner or my children to benefit from my super for whatever reason, and I wanted, say, my brother or sister to benefit from my super, I would have to specify in a binding death benefit nomination that my superannuation is paid to the executor or to the estate, and then through my will specify that the proceeds of my super is to be paid to my sister. The reason why I say this is because if I have an industry super and I specify within that industry super that it's going to be paid directly to my sister, unfortunately won't be seen as valid and she'll miss out.
Okay, right. A few things to think about there.
Yeah, absolutely.
Okay. Could you tell us any interesting client situations that you've come across?
Yeah.
Maybe recently or just throughout your experience?
Yeah, definitely. Career? So I think that some of the more interesting clients that I've had have stemmed from people that have taken it upon themselves to create their wealth portfolio, but also structure it in a way that I suppose is dependent on a lot of trust and things going very well. And unfortunately, as a lawyer, I've obviously seen things go not particularly well. So, for instance, I've had to advise some clients who were quite high net worth individuals. Both of them got together later on in life, so they were in their 50s when they got married. They sold a lot of their assets that they held in their personal names, and then they acquired wealth together. But when they did buy their wealth, they bought all of these properties as joint tenants, which means that the rule of survivorship applies. So on the death of one, the survivor will absorb everything. But they didn't update their wills. And so they could have been in a situation where it was quite literally potluck in the sense that one of them would die, the survivor would absorb everything, and then basically their children would benefit from all of that wealth. And so one side's children could have effectively been left out. So obviously there's some structuring issues that could have been handled a little bit better, but also there's solutions around that as well. So it's possible to enter into what's called contractually binding mutual wills to say that even on the death of the last survivor, that it still has to be split equally between all of the children of the partners as opposed to just one side. So I suppose blended families, which is quite standard now, I suppose. It's no longer that interesting because it's that common, but it's just those things to consider of building wealth together, maintaining the protection of one another, whilst also remembering that you've got children from a previous relationship that also need looking after.
Yep. Okay. Here's a question. Maybe, I'm not sure how you structure this, but ultimately I want to find out what got you into wills and estates, and what you're passionate about.
Yeah, it's a really good question. So I think that I was going to say that births, deaths and marriages is unavoidable, but I suppose marriage could be avoided if that's not what you wanted. But I suppose there are some certainties in life, which is that, if we're lucky enough to be here, hopefully we all live long lives and prosperous lives. But what is certain is that we have death. And I suppose it's really important to come to the table prepared for these things. And I like to consider myself as approachable and empathetic. So sometimes having these sorts of conversations can be really difficult and confronting. I don't think that we just like to sit there and contemplate the fact that ultimately we're not going to be here for much longer. But I suppose that if we sort of frame it in the conceptualization of, I want to do good in the world, I want to look after my loved ones, and if we frame it in that way, it makes the conversation much more palatable. Yeah, that's right. So, and that's what I'm really passionate about, because I know that it's something that people need to do. People are reluctant to do it. So hopefully through education, we can get them over the line and protect their assets.
Yep, 100%. 100%. Here's another question for you. Some people are of the belief that if you're not married to someone, but you live with them, that they don't automatically say if something were to happen, they would get a share of your assets. What are your thoughts around that?
Yeah, so I mean, this is an interesting one, because I suppose wills and estates blends in so neatly to property and to family law considerations. You don't have to be married to someone in order for them to be considered to be your partner. So usually if you live with someone in a domestic relationship to the exclusion of all others, they are going to be seen as your next of kin. Mm-hmm. And so therefore they have the standing to then inherit your estate, or I suppose to be a beneficiary depending on your circumstances. So I suppose there are times where people are not sure if that is the person that is right for them, and whether or not they ultimately want that specific person to benefit from everything if they've only been together for 2 years or so, when they might have other siblings, or they might be quite early in their journey of life. They could be in their early 30s. Things like that. So I suppose another element that comes into the equation of estate planning is having a prenuptial agreement in place.
Yeah. And how does that work? I know this isn't your area of focus, but can you share any tips with us?
Yeah, absolutely. So a prenuptial agreement is basically a document that specifies what will happen to assets that are individually held or jointly held by two partners if the unfortunate event were to happen of the ultimate breakup. So I suppose while family law is not the same thing as a business transaction, you can compare it to a shareholders agreement. Mm-hmm. That if the two people that are operating this business of a relationship can't see eye to eye, what's going to happen to the assets that are part of that relationship?
Yeah. All right, fantastic. Lastly, any tips or tricks you can share with us? Any words of wisdom?
Go to see a lawyer and a tax accountant.
Yes, they work together to build your assets and make sure they're actually...
And protect them, that's
protected.
Right, yeah. So I suppose we don't know what we don't know, so it's good to equip ourselves with that information, stay informed, and have the right advisors at hand.
So I'm just going to be frank, right? Sometimes it's a bit hard for me to talk to clients about these sensitive topics. So actually doing a video like this with you helps them understand these various moving parts, and it's a way that educates them but doesn't really push them and make them feel uncomfortable. It's sort of a very easy way to learn and educate themselves and say, okay, this is something that we actually really need to have a look at and get done.
Absolutely. Yep,
So if we want to get in
spot on.
contact with you, how do we do that?
So you can find me at Batten Sachs. I'm sure that Mina will be able to also share my email and my mobile number.
Yep, we'll do that.
So yeah, that
And you're on
would be
LinkedIn
perfect.
too?
Yeah, on LinkedIn as well.
Fantastic. Any other social media platforms?
That's basically it.
That's basically it. Oh, I thought you were famous.
Not today.
Not today. No TikTok dancing videos.
No, not for Wills in the States, funnily enough.
All right, thank you so very, very much for giving us your time today. We appreciate it.
Thank you.
You're definitely very personable. You're someone who makes the topic easy to understand and also is very welcoming. That's what I find about you. So again, thank you very much for your time and we look forward to the next one.
Yeah, absolutely.
Fantastic. Thank you, everyone.
Cheers.